Yeah, so modern attachments has been a topic I've heard at a few master's conferences, and this Noom case really highlights that. Alicia, I would love to have you do a deep dive here for us to help us understand this further.
Yeah, and I just want to say that I was just taking notes on that part, Jerry, when you were talking, because a couple of the things that you said really resonated with me with some things that I'm working on, and it made me think about things I need to ask custodians and stuff. So that's why I love being on these panels, because I'm like learning. Yeah, Colleen, right? Because I'm learning as I go. I'm thinking, oh yeah, that's something I need to think about. So thanks for that. Yeah, so the Noom case is so interesting because I think it really illustrates why the concept of modern attachments is so tricky, and why there are so many considerations and why it's such a relevant topic right now. Because, I think this case really is a culmination of all the things that we've been talking about today and all the considerations that you have to think about and what the courts are really looking at when ultimately a dispute comes in front of them that they have to decide. So I'll give a really high level overview because I'm sure most people are familiar with this case by now, because a lot of people are talking about it. But in the Noom case, it really it deals with, I think, four main themes. First is proportionality. Second is the process of collecting data. Third is the format of the data itself and sort of what categories of documents certain types of data would fall into. And then the last is deference to protocols, or what the content of a protocol is. So in the Noom case, this was a motion to reconsider a motion to compel that the plaintiff filed. And what had happened in this case is that the defendant, through negotiation of the protocol, had used Google Vault to collect data. And in collecting data via Google Vault, it did not keep hyperlinks in emails affiliated with those emails. So basically, a lot of us are used to using things like iManage, for example, or a OneDrive, where when you attach a document to an email, you're linking it to the actual location where that document is stored, as opposed to attaching it like a Word document or something where you can just, open that copy up in the email. So in this particular case, when they did the collection via Google Vault, it was not keeping those families together. And what it would do is it would collect just the email, and then somewhere else, if an attachment was independently considered to be relevant or responsive, it was being grabbed separately. And so when the documents were then produced, you were getting two things. You were either getting emails that had abandoned the attachments altogether, and you just got the email with you could see a hyperlink, but there was no attachment produced anywhere in the production. Or you would get an email that was produced and then the attachment produced somewhere else, but they weren't connected up. So there wasn't any metadata to link the two in a family structure. And so you just sort of have to go hunt and try to find if those attachments were actually in the production or not. And the defendant, so there was a motion to compel that the plaintiff lost, and then they filed a motion to reconsider and they lost that too. And the defendant basically said a couple of things. They said, number one, hyperlinks are not attachments. And so because they're not attachments, we did not have to collect them together, and we didn't have to produce them as a family unit. The court agreed with that, which I think is a little crazy. And the reason they agreed with that was twofold. Number one, they legitimately the court made the argument that they aren't actually attachments. That just because you link something doesn't mean that it's integral to the context and content of that communication, because there are times when you could link things like, for example, a link to a case, or a link to a web page or something, and that isn't critical to the content of the communication. They also said that they weren't attachments because in the protocol did not define the word attachment. It didn't define it at all, but it didn't specifically say in the protocol that hyperlinks were considered attachments. And if it had said that, the outcome, I think, would have changed. If that had been defined in the protocol, I think the outcome would have changed. So the court agreed and said hyperlinks are not attachments. And so they don't have to be collected and produced together. The court also, there was also a proportionality argument. Noom said it would be disproportionate to the case if they had to go back and spend money to recollect everything, and to go back and put everything together, and that it would be disproportionate, and the court agreed. And Noom also made the argument that under Sedona Principle 6, they're best situated to determine how to do the collection. And that they chose to use this particular tool. It was negotiated in the protocol. And so that's that. And the court agreed with that as well and said, yes, the responding party is best situated to, use reasonable methods to respond to requests. And so ultimately, the one final note that the court made was that Noom had always been willing to sort of point plaintiff to the location of attachments in a production if there were specific questions that came up. So if the plaintiff was looking at an email and there's a hyperlink to some document and it seemed like that document was really important, then they could ask Noom, and Noom, the defendants, would tell them where that document was in the production. Now, I think that's highly inefficient. I think that's just a wild way to go about doing things. I totally understand the proportionality argument, and I understand, to me, that's what is really persuasive, is that this was negotiated in the protocol and they did it the way that they agreed on. And, unfortunately, hyperlinks were maybe not well contemplated before the process started. And so ultimately, this is where they ended up with what I consider to be a highly inefficient process. I think that hyperlinks in this case would be attachments. They certainly are demonstrably attachments in certain circumstances in this case. And to have to then go back and forth and ask, for specific documents in the production, I think is really inefficient. And they're probably going to end up spending some time and money having to go through that process. But really my takeaway on this goes back to the points we've been making all along, which is everything is changing all the time. And you have to get a handle on data really early on in a case so that you can understand what is and isn't going to be important. And, in this case, both parties had very sophisticated ESI teams, and I'm not sure that anybody really missed anything. It just is a really good example of how everything is changing so fast. And it's really important to have people with knowledge and expertise, who can think of these things and who can say, oh, you're using, Google to manage your documents. Well, that's cloud-based storage. So there might be hyperlinks to documents as opposed to attachments. Let's figure out how we want to deal with that. So that's sort of what the case looked like. And I think it's just a really good example of all the considerations that need to be made and to be thought of throughout the duration of a case.
It's great how what you just summarized does tie everything we're talking about together, and how the Noom case sort of shows that, yes, it's a bit wild, wild west out there still, and it will be for quite a while. There's flexibility in approaching that problem, even midstream or in the end. But the big takeaway here is as far upstream as you can possibly get and have those conversations and have those considerations, bring in the experts early. It's much easier to, solve those problems earlier on than have to go back and make it up. And in the Noom case, they just didn't in some instances, right?
Yeah.
They argued it away. Yeah.
Yeah. Well, and I know Jerry has wants to say something, but I'll just say that I don't know if pre-planning would have necessarily changed this. It's hard to really say, but what I will say is that hyperlinks are incredibly common. And so hopefully, if nothing else, people watching this will think about hyperlinks next time they're approaching their case and they're thinking about an ESI protocol, because the reality is hyperlinks are increasingly common. I mean, at law firms, we obviously use them through iManage. Businesses are using them as part of their cloud storage. So this is really, really something we're going to be seeing a lot more of. And so if you get nothing else out of this, at least think about hyperlinks next time you're making, doing your negotiations.
Yeah, I think ultimately there needs to be a distinction between the types of hyperlinks. It's not that hard to distinguish between a hyperlink to a external web page versus an internal OneDrive, right? So there's some easy parsing of those links that you can do to distinguish between the two. And platforms like Microsoft 365, if you've got the E5 license and you're using eDiscovery Premium as part of their Purview offering, the modern attachments get pulled in to the collection. No longer are we as forensic examiners required to collect it from a bunch of different places to reassemble the Teams chat, for example. So Teams chats and emails coming out of M365, they've already taken care of that. But that is an enterprise grade platform, right? There's plenty of platforms out there that are using modern attachments that don't provide you with that convenience.